Hi there. I am James R. Copeland. I am the Director of Legal Policy for and a Senior Fellow with the Manhattan Institute. It's my pleasure to welcome you to this afternoon's eventcast discussing today's oral arguments in Students for Fair Admission v. Harvard and Students for Fair Admission v. the University of North Carolina, the companion cases before the U.S. Supreme Court that consider race discrimination in college admissions, what proponents of the practice call affirmative action. These cases specifically involve alleged discrimination against Asian Americans. The challengers argue that the 14th Amendment and that federal law forbid race discrimination by educational institutions that receive federal funding. Each require a race-neutral approach to accepting potential students. The constitutional claim only applies to UNC, a public university, while the statutory claim applies to both institutions. I'd like to thank those of you who've been patiently awaiting our beginning. The oral argument today was scheduled to end at 12:30, ended up running until about 3 o'clock, which is why we bumped back our start time slightly to get before we got going. So let's get going and discuss the oral argument. We have an outstanding expert panel of Manhattan Institute scholars to talk about these oral arguments today, and I'm going to introduce them one by one. First, my colleague Ilya Shapiro, an MI Senior Fellow, Director of Constitutional Studies for the Manhattan Institute. Ilya is the author most recently of Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court, published in 2020. Earlier in his career, Ilya was a vice president of the Cato Institute, director of Cato's Robert A. Levy Center for Constitutional Studies, and a publisher of the Cato Supreme Court Review. He also served most recently as executive director of the Georgetown Center for the Constitution for a brief but consequential period. Ilya has filed more than 500 amicus briefs, friend of the court briefs in the Supreme Court, including in this litigation, one of the top constitutional and Supreme Court scholars in the country. Next, I want to bring on Gail Harriott, an MI book fellow and a professor of law at the University of San Diego School of Law and a member of the U.S. Commission on Civil Rights. Gail's been working on these specific issues since before Ilya and I were even in law school. She chaired the 1996 campaign for California's Proposition 209, which amended the California Constitution to prohibit state-sponsored preferential treatment based on race or sex. She currently serves as the chairman of the board of the American Civil Rights Project, and among a long list of publications, in 2021, Gail co-edited A Dubious Expediency: How Race Preferences Damage Higher Education. Finally, I'd like to bring on Wei-Hua Chen, an adjunct fellow at the Manhattan Institute, who is the founding president of the Chinese American Citizens Alliance of Greater New York, an all-volunteer organization advocating for equal rights for New Yorkers, especially in education, which brings her very close to today's argument. She actually was there in Washington, D.C. Last night and today during the argument. A graduate of Yale, Princeton, and Columbia, Wei-Hua is a relentless advocate for the Chinese American community, and she has a professional background in private equity. Thanks so much for joining us. So first, I want to start with Ilya, and we'll go around and just react to today's oral argument. What stood out to you? What did you see? What should we take away?
Well, unlike a couple of last term's high-profile arguments, including most notably the Dobbs abortion case, I don't think there were big surprises here in the sense that there was no statement by a justice or the advocates that caused a rethinking by the other justices or how commentators are expecting this case to go. If you're following along at home now, this prediction is worth what you're paying for it, but it's I think it's going to be 6-2 against Harvard, with Justice Jackson recused in that one, and 6-3 against UNC, meaning the court is likely to say that you cannot use racial preferences because there's no operative way of tinkering with that machinery. Now, having said that, again, that's just the top line. That's perhaps the least interesting part. That'll be interesting in June when that actually happens. But I thought a notable moment was when Chief Justice Roberts got the lawyer for Harvard, Seth Waxman, to admit that at least sometimes race was determinative in admissions decisions, which is supposed to be unconstitutional according to the Supreme Court's precedent. And Waxman said, well, sometimes when there's very highly qualified applicants, race might matter, just like being an oboe player if the orchestra needs an oboe player. And Chief Justice Roberts replied, "We didn't fight the Civil War over oboe players," expressing the frustration, I think, of those who are opposed to racial preferences. So I'll leave it there. But like I said, I don't think the commentary or the conventional wisdom really changed, even though we had 5 hours of whether you call it painstaking or a thorough argument today.
Thanks so much, Ilya. Gail, we'll turn to you. What stood out at today's oral argument?
Well, okay, I agree with Ilya that there were no surprises here. On the other hand, I thought that the argument, particularly at the beginning, had a certain Alice in Wonderland quality to it when they were talking about, is this one factor among many, or is it something else? I mean, for goodness sake, in any decision about whether to admit someone to a college, there's going to be more than one factor. You need to be a sentient, alive human being. You need to graduate from high school. You need to speak English because the classes are conducted in English. You need to, and there's a huge number of things that are going to be considered. But like the idea that if it's only one factor, that's okay. I mean, what I find is a good rule of thumb is when someone says something like that, flip it. Ask yourself what they would be thinking if it were preferential treatment for whites. To say, well, it's only one factor. We give an advantage to whites, but it's not the only thing that matters. Everybody would hear that and immediately know, oh, no, that's raw race discrimination. And yet they were acting as if it wasn't here. And it just gave it a feeling of unreality to me.
Interesting. I thought the same thing. This is something our newest justice, Ketanji Brown Jackson, kept sort of hammering on, and some of the other justices as well. And it really didn't make sense to me. We can get more to it in a minute, but I want to turn to you, Wei-Hua, and what were your takeaways from today's argument?
Well, I thank you all for your comments here, because you're the great legal minds over here. I'm looking at it from where a layman would see the response. The response initially is that where are these racial preferences? Because what happened is that you had Sotomayor saying that, well, without racial preferences, it would have a tremendous, precipitous was the word she said, a precipitous drop in the enrollment of African Americans. And so that means that it really does count. And then on the other side of it, she'll say, oh, well, it doesn't matter. We're talking about a light touch on the scale, a tip of a scale. Now, if that were true, if that were the case, then later we wouldn't be here and we would say, well, if it's a light tip, we could just get rid of it. And if it's a heavy tip, then that's unconstitutional. It's done. It's done. This should not even be an issue there. So I think that we have to look at this and say that this is the time to get rid of this and find the kind of justice that we were all looking for.
Yeah, there's this sort of unreality. This doesn't really matter, but it's essential. And both arguments are sort of being juxtaposed here. So one thing we want to just sort of step back from this, and there were lots of different questions. Again, it was 5 hours of discussion, but one thing that was being pushed both by some of the advocates defending the universities, as well as some of the justices that we could expect probably to rule on their behalf, was this notion that if we use an originalist methodology, and it's important to realize there's two separate sorts of claims here, right? There's a 14th Amendment claim, which is a federal constitutional claim, which applies to UNC, a public university, as I said, but not expressly to Harvard, although the standard that the court has traditionally used for Title VI, for the Civil Rights Act statutory claim, would apply the same basic standard traditionally on this, which is the statutory claim that brings Harvard in as a recipient of federal funding. But the argument here was that there's an originalist problem here, that the founders or the framers of the 14th Amendment, the ratifiers of the 14th Amendment, would have been just fine with sort of racially based classifications like this. Ilya, what do you think about that?
Yeah, some of this discussion about what would originalists think about this amounted to what I've called in other contexts prog-splaining, progressives who don't really believe in originalism trying to explain what it means. But really, I think it's a valid point to look at what the enactors of the 14th Amendment in 1868, how they would have treated what the meaning of equal protection, and did they use race? Because we had the Freedmen's Bureau, for example, and other federal policies meant to remedy the harms of slavery and equalize the legal standing of freed slaves and also free Black people more broadly. Building on the Civil Rights Act of 1866, they were very conscious, not so much of race, but of the status and stigma and badges of slavery. And so, in the American experience, slavery is tied to skin color and race, of course, but not in the course of human history necessarily. And so, there's a battle among historians and historians' briefs that filed as amici here in this case. But it boils down to two things. One, are they really looking at race, or is it status, the status of being previously legally subservient or enslaved versus now being free? And also remedying harms done directly to people who suffered from the previous invidious discrimination, not in some theoretical sense for their descendants or others who might look like them in terms of race. And they got into some more nuanced argument about, well, what do you do now for, do you distinguish between descendants of slaves versus, Black immigrants from the Caribbean or Africa or something like that? And that's a more nuanced discussion, I think. And I think the lawyer for Students for Fair Admissions correctly said that would be a preference given by ancestry, which has certain other kinds of jurisprudence and problems, not directly by race. But in any event, it's not simply the case that this simplistic prog-splaining view, as I've called it, that just because there was the Freedmen's Bureau and other federal programs that were meant to directly benefit freed slaves in America who were Black, that doesn't mean that ipso facto racial preferences now are the public meaning of equal protection protects them.
Yeah, I think that makes a lot of sense. And there was an interesting sort of aside with Justice Gorsuch on this, saying, well, the 14th Amendment, this federal stuff is interesting, but the 14th Amendment really applied to the states, not the federal government. And let's look at what the states were doing. And I think there were a couple examples from Kentucky and South Carolina that the universities are claiming suggests race consciousness. And there was a little bit of discussion about that, but interesting sort of stuff for the inside baseball here. I want to turn back to you, Gail, now, because this is sort of the constitutional setting for this. But for me, as sort of an outsider looking in on this, in the sense that I'm not the constitutional law guy. That's Ilya. I look much more at statutes and common law claims and the sort of work I do. And to me, the statutory Civil Rights Act claim, which applies clearly to both universities, looks like it should be outcome dispositive here looking at this case. I mean, the statute's pretty clear. No person in the United States shall, on the grounds of race, color, or national origin, be subjected to discrimination under any program or activity receiving federal financial assistance. That seems pretty clear. And Justice Gorsuch asked about this as well, because the parties didn't really brief this much, although there were plenty of friend of the court briefs touching on it. And he was sort of pushing on this point, should we look at this? Because the statute looks pretty daggum clear here. Some of the answers there surprised me a little bit. What did you think, Gail?
Well, I think you're absolutely right that Title VI is very, very clear. I mean, you can't mistake it. You read the language and it says can't discriminate on the basis of race, color, or national origin. And the problem that came up back in 1978 in Regents of the University of California versus Bakke, is that several justices, and they formed a majority, 5 of them, interpreted that to mean simply that what constitutes discrimination under Title VI should be the same as what would constitute discrimination under the Constitution, under the 14th Amendment. And the reason they said that, and this is tricky here, they looked back at the legislative history, and there were a couple of members of Congress who said all this will do is apply the Constitution to private parties, non-governmental parties that receive federal funds. But the reason they said that is that their understanding of the Constitution in 1964 was that it was a flat ban on racial discrimination. And so, sure, but in fact, it's very clear just from the language of the statute, they meant to ban race discrimination. They thought that's what the 14th Amendment did as well. But even if they're wrong on that, they prohibited race discrimination. But we've got that precedent in the way. But at the same time, we also have new precedents. And Gorsuch is very, very familiar with one of those precedents, and that is the Bostock case. And the Bostock case actually interprets Title VII employment law. This is the transgender case where Bostock and Justice Gorsuch, writing the majority opinion, very mechanically applied the term discrimination and said, hey, it's just a question of, is somebody, is a male individual who prefers to dress in feminine ways treated differently from a female individual who prefers to dress and use the cultural signals that we consider feminine. If so, that's sex discrimination. The same thing applies here. I mean, it's even simpler, actually. Is there discrimination on the basis of race going on here? Absolutely. Everybody agrees. Even when they look at the Harvard case and say the judge found that Asians were not discriminated against, they only mean that judge only meant vis-a-vis whites. And I think it's obvious that it was incorrect. But nobody's saying that Asians are not discriminated against vis-a-vis African Americans or Latinos. I mean, it's very clear in the Harvard evidence that it's true. And Gorsuch is saying, look, we're arguing about originalism here, but why bother? Why not just look at Title VI, which is absolutely clear on its face? And the only reason that we're even considering the opposite is that in the Bakke case, we kind of got lost here. But why not be very clear about what this statute requires, avoid the constitutional issue, and just decide it on the statute, which again is absolutely clear.
Although it was a telling point in the argument that Gorsuch got the Solicitor General, Elizabeth Perlegar, to say that the word discriminate was clear and unambiguous for purposes of Title VII. That's the Bostock case, but it was ambiguous for the purposes today for Title VI.
Lunch the laugh test. It's lunch the laugh test. But like one thing that was odd was the attorney for SFFA said, well, we didn't really brief Title VI. Fortunately, some of the amici did. And so it cannot be said that this issue was not briefed before the Supreme Court. It's a much easier issue. And personally, if I were a justice of the Supreme Court, and I add that I'm not, so that doesn't make carry a lot of weight here. If I were, I'd be inclined, as Justice Gorsuch seems to be, to put this on Title VI. It's a much easier legal issue.
That would be my instinct too, and also sort of just my instinct. Normally, if you can resolve a case under the statute, you do it, and you leave the con law case to another day if it arises. But we'll see how that actually plays out. I want to go back to you, Weiwa, and sort of come to you with what Gail was talking about before, and then we can sort of go around a little if we want to, or go back to Gail, or Ilya can opine. This sort of multi-factor point, because this is something Sotomayor hit on some, Justice Sotomayor, and Justice Jackson kept coming back to it, saying, well, there's 40 factors, so we can't really say race is the important factor here. And in fact, when we look at the record here, most white people don't get in, most Asians don't get in. I mean, Harvard's very, very selective. So, how can we even tell? We can tell. Find me the person that was discriminated against. How does that ring to you? What's the problem with that sort of question?
Well, the very first point is that if it really didn't matter, then it shouldn't be there. We should all agree that this racism, this racial tilt should not exist. Because if you're saying that, well, there are all these other factors, well, then focus on the other factors. When you keep on talking about race neutrality, right? So we should be at the point of being able to say we don't need to think about that any longer. And that was the point also nearly 25 years ago when Sandra Day O'Connor said that this is extremely, extremely dangerous what we're doing over here, to say that we can even consider race for this. And to be here after so many years and say that we still need to keep it up, that was another thing that came up through the course of the hearings. Yet, what is the end point? How long is this going to take? Is it going to be another 25 years or another 50 years? What does it mean if it means for an infinite amount of time? Or does it mean that we can jigger what that amount is too? Because today, well, we feel that this amount is appropriate for reaching what we consider to be a racially diverse amount. But what is the magic in that? So you're pegging these numbers, and when the court is asking, what point, what number, what are you talking about? If we cannot define that, we get ourselves into this trap of looking at an individual who is applying as a statistic of race, as opposed to an individual who should be considered on those 40 other important merits for the true diversity.
I think that's right. And it was an interesting point. This sort of juxtaposition, it matters, but it doesn't matter. And Justice Thomas at one point asked the counsel, saying, oh, well, you say it's only 1.2% relevant. So how is that a compelling state interest if it's really not that relevant? And they kept trying to sort of have it both ways. Of course, the relevant point is here is, of course, it's extraordinarily relevant, which is why some of the data that the justices went into, and Seth Waxman, the former Solicitor General arguing for Harvard, sort of got into this, these data don't really matter in terms of the academic metrics. They're only ones we do for the Ivy League. Basically, they don't really matter. They matter for our athletics. They're not important, et cetera. But that's why we have this situation where the black applicant in the 6th decile has a better chance of getting in than the Asian applicant in the top decile, and these sorts of things, which is, in an ordinary discrimination case would be quite compelling sort of statistical evidence on that.
I thought I heard Seth Waxman say that 45% of Black and Latino students are in Harvard because of racial preferences. That's not insignificant, to say the least.
Yeah. So it was a huge concession there, and of course that could be the case, right? It's most of us would never make an NBA draft combine. That doesn't mean that if the NBA came out with a rule and said, oh, it'll help our ratings and our sales if we have more white players, and put a thumb on the scale, that wouldn't be outcome determinative in a lot of cases, even if most of us would be too short and unathletic to even begin to get to the NBA draft combine, right? I mean, it's just, sort of an implausible sort of statistical analysis, but one that, at least 2 of the 3 progressive justices were hammering over and over again. So going back to you, Ilya, then what about Justice Thomas was sort of trying to flip this on its head and talking about this notion of deference, and he was going back to the old segregation cases, but basically saying, why are we deferring to this sort of diversity rationale in the first place, and these universities purported discrimination? Explain what he was getting at with this, because Justice Sotomayor sort of didn't even like the line of questioning, but what was he trying to get at on this?
Yeah, he was making lots of folks' heads on Twitter explode, at least those who hadn't left since Elon Musk took it over, by equating segregation with affirmative action, with racial preferences now. And he was saying that the sorts of sort of hand-waving nebulous arguments about diversity, which he also said nobody's been able to define for me, it seems to mean everything for everybody, and which is also kind of a telling question. He's not playing dumb. He's just saying it's been used to justify all sorts of things, but nobody can put a finger on it. And when there's enough, or as in past cases, it's you can still give preferences. In the Fisher case, the UT Austin case a number of years ago, you can still give preferences to Latinos even when they're more represented on campus than Asians and things like that. He's basically saying you're coming up with these artificial pretexts to justify racial preferences in the same way that segregationists were. Now, he's not saying that Harvard and UNC and other university administrators are malicious and want to keep anybody down, but he is saying that they're beholden to a particular ideology and are doing what they can to try to come up with arguments to preserve it.
So Jim, Jim, the original sin in this situation on the deference argument is Grutter versus Bollinger, where Justice O'Connor's opinion said that the court was deferring to the University of Michigan on whether or not diversity is indeed a compelling interest. And like when lawyers read that, it was really laying an egg, to put it mildly, because the whole point of scrutiny is that it's the court's burden to like knock itself out to figure out whether or not this is really necessary. Is it really compelling? And so when that decision came out in 2003, anybody with any familiarity with constitutional law and strict scrutiny was saying, whoa, they're deferring to the university on what's a compelling interest. And I think that has, bothered Justice Thomas ever since, because, he correctly points out, hey, back with Brown versus the Board of Education, there were plenty of school districts who came up with experts who said, we're experts on education and we can tell you that segregation is good for education. This is what should be done. Had they deferred back then, this would be a very different country than what it is today.
If I can correct one thing, I'm not sure Grutter is the original sin in terms of affirmative action, at least not, past slavery and Jim Crow, but in terms of university practices, it's Bakke itself, the 1978 case, where based on one vote of Justice Powell, he's the only one that created this diversity rationale as a compelling interest. If he had gone with either side, with the whole nature, the other side, meaning four justices said, yes, you can use race to remedy past history of discrimination. Four said, no, you can't use race at all. He came up with this diversity, use race as one of many factors. And Grutter, built on that.
Yeah. They never talked about strict scrutiny in the Bakke case. There was no word about deference. Thomas is zeroing in on that word where O'Connor uses it in Grutter, and that was what caused everyone to say, "Whoa, what's happened to strict scrutiny?" That is the case that does that. And what's weird is like in the Fisher case, they come up with this split idea. They go, okay, strict scrutiny we ordinarily apply here, and it requires a compelling interest on the part of the governmental entity. And then we have to look at whether or not what they're doing is narrowly tailored to serve that interest. And in Fisher, they say, well, we deferred on compelling interest, but we won't defer on narrow tailoring. So it's going to be a split thing, but it makes no sense. That is a distinction that you cannot draw because the two questions are too closely related. And the example I like to use is the Korematsu case. Remember the old case about Japanese American internment, where they had to decide, does this survive strict scrutiny? This was a new idea at the time. But it depends on how you articulate the interest. In Korematsu, if the compelling interest is national security, well, of course it's compelling, but all the work is going to be done by narrow tailoring. But if the compelling interest is articulated in a different way, if you look at it instead as, is it a compelling interest to have to take Japanese Americans and put them in camps that are far away from the West Coast because we're concerned about the possibility that they aren't loyal to the United States? Okay, that's doing all the work. And once you decide that is a compelling interest, then narrow tailoring is easy. Those two different sides of strict scrutiny are too closely related. It's too much a question of how you look at it. You can't say we'll defer on one and not the other, because it just means they're going to start talking about them in a different way. So Grutter and Fisher together make absolutely no sense. And it's time to say no deference anywhere.
I don't really like using Korematsu as a precedent for this because using the internment camps as a precedent is not a really good thing. And also, when we talk about the special conditions of a war, that was really supposed to be a very special, extraordinary circumstances of
I'm
war.
not using it as a precedent for its result. I'm using it because it makes a pretty good example of why the two questions are closely related. I think most people agree Korematsu came out wrong.
Right, right. So it came out wrong for that, for
Don't worry,
using
don't
it for this case. That's right. I think we were in agreement over there. But I think that this diversity question is one that was raised today. And I think it's a question that we all say, what is racial diversity serving other than for skin tone? Because if we're looking for diversity for university, the diversity should be thought. And that was the original intention of having this different racial diversity, that it would help enhance diversity of thought. But I think very compellingly, SFFA has said that you don't have that now. You have, if anything, a much less diversity than you found several decades ago. So it's not working. So we should go back and say that if it doesn't work, let's try to get the real diversity. And what is, after all, these kids there for? What is the educational aspect of it? Are we actually enhancing the education abilities for people when we tell them to address themselves and think of themselves as racial beings first? How does it enhance their ability to do computer science, to think of themselves, oh, I am a Black computer scientist versus I am an Asian computer scientist, therefore my computer science must be different? I don't get that, and nobody should get that. And we started getting that a little bit of thing that somebody started talking about doctors. Should we have diverse doctors? Should our doctors look like ourselves? And I would say that I want a doctor who's extremely good and will treat me well, as opposed to somebody who happens to vaguely look like me. I don't like that term, which did come up today too, that we want people who look like me. And look, that's not what we want, because very often we want to look at people as individuals, and you could say that everybody looks a little bit different, even in a family. Even in a family, when you have the same parents, your siblings may look very different. But you should be looking for those people who can best address what makes a good student body, not by their color features, but by their abilities to bring their skills and interests to this community.
Yeah, Justice Thomas kept hitting this diversity point on, what's the educational value of diversity? And I don't think ever got a very good answer. And those of us who see the universities, it's pretty obvious their view of diversity is a bunch of social justice warriors who look like a Benetton ad, right? I mean, that's what they're looking for. We've got a lot of good questions flowing in here.
And even then, there's these arbitrary points that David Bernstein wrote about in his excellent book, Classified, which we did a forum on here. I think last month. We're talking about how even if we're talking about skin color as a shorthand. Well, if you're a dark skinned North African, that's white, versus if you're a blonde Spaniard or Argentine, that's Hispanic. And it's all this. There was Justice Alito brought out an exchange where he talked about what if it's an Afghan who brings a really different experience? How is that even the same as someone from China, and they're all Asian? He was showing that arbitrariness, but he even got that wrong, because Afghans are treated as white, as not Asian. And even, Afghanistan has many racial minorities within it. There are Turkmen, for example. A Turkman, I don't know how the term is, from Afghanistan is white, but if his passport is from Turkmenistan, then all of a sudden he's Asian again. So lots, even, inconsistencies within the paradoxes.
Yeah, we've got various questions rolling in here on this. One of them was on this, why did the justices continue to accept the shibboleth that diversity is a good thing? We got into that. Related, the racial categories in which applicants are assorted are irrational. And a third part of that question is much has been written on how damaging it is to matriculating underqualified students, for example. And this is something you've written a lot about, Gail, in terms of mismatch. That's something we didn't hear today, unlike in some other arguments. And why do you think that is? Do you think it's going to not play in this case, or what do you think is going on there?
I thought it was interesting that it didn't come up, but if you will remember, back when the Fisher case was the oral argument in the Fisher case, Justice Scalia asked a question about mismatch. And I think, granted, he didn't word the question as well as it could have been. It shows that if you're going to ask a question on an issue of race, maybe you better think about how you're going to phrase it. But when he asked a question about mismatch in the Fisher case, it went viral. It was all over the newspapers. People didn't I think a lot of mainstream journalists had no idea what he was talking about. And that's important in itself, that an issue like mismatch that shows that students whose academic credentials are going to put them at the very bottom of the class, when you're not doing them a favor to admit them to a school where they're not going to be able to compete as well, particularly if their interest is in science or engineering. And this is not something that only applies based on race. It's anybody that gets preferential treatment, particularly those who want to major in science and engineering. You're making it harder for them, that they are much less likely to get that science or engineering degree. In fact, they're much more likely to do well, regardless of what area they go into. They're much less likely, if they go to law school, to graduate and pass the bar than if they'd gone to a school where their academic credentials put them in the ballpark with other students. And I think, it's true. At this point, we have enough evidence to show we would have more African-American scientists, more African-American engineers, more African-American lawyers, and so on, if students were going to schools where their academic credentials put them in the ballpark with their fellow students. And yet nobody mentions this. And I think nobody mentions it because they didn't want to end up in the headlines of the newspaper the way Scalia did in the Fisher case.
And just to be clear on this, to anyone listening out there, I mean, the point here is not that there aren't qualified Black applicants for any one of these schools. It's that if you have these disparities in terms of the percentage of any groups in these schools, and the top Harvard, Yale type schools are vacuuming up X% of all these, Princeton as well, of course, Ilya, vacuum up X% of all these applicants, and they vacuum up all the top Black applicants with these sort of admissions policies like Harvard's data clearly suggests they're doing. Then you're going to have mismatches down the line with other universities because you're getting the 80-90% of the rejected white Asian applicants of these universities, and then you're getting the quantitatively and qualitatively different, substantively different Black or Hispanic applicants at some of these other schools. And one of the best ways to evidence this is sort of the great data on HBCUs. I mean, I'm a trustee of a historically Black university, and HBCUs put out a substantially disproportionate share of scientists, engineers, and things like this, and there's a reason for that, right? And it's not exclusively this, but it's a part of this. Yeah. So
I think Richard Sander and Stuart Taylor filed their regular mismatch brief. They wrote the book on it quite literally, called Mismatch. And one of the things that they point out is that this also contributes to the thing in which I've had a lived experience, this cancel culture on campus and the downgrading of civil discourse and so forth, because you have, due to this mismatch effect, the clustering of certain racial minorities in the bottom quartile of grades and so forth, and that leads them to believe that they're being mistreated by the university, and the point is they effectively are, but not while they're there. It's during the admissions process.
I do want to point out, if you're teaching a class at Georgetown Law and make this point Ilya just made, you could lose your job, but because we've seen that happen before Ilya's drama there last year. So let's just see if one of the questions we got from the audience here is there any chance that there could be a public-private distinction here? And most of us who follow this from the outside looking in, I think because of the way Title VI is constructed, that's probably not going to be the case. But would think, well, okay, the government's one thing, but if Harvard's a private school, and we've had a lot of discussions internally about Harvard's a private school, maybe they should be able to do something a little different. Is there a chance we get that sort of split? I don't think so, but what do people think?
If Harvard decided not to take any federal funding, and I don't think they will do that, but if they were to decide not to, then Title VI would not be involved. They would not be violating Title VI. I think you can, look to Massachusetts law. Is there something in Massachusetts law that would prevent them from doing that? I don't know of anything like that, but then I'm not a Massachusetts lawyer. And then there's Section 1981. If you could construe this as a contract, would there be some ability to say, well, even if they don't accept federal funding, they can't discriminate on the basis of race.
That's another federal civil rights statute, to be clear.
Right. It's a very old one, and weirdly enough, The original version of 1981 was passed right after the Civil War, and it meant something completely different from what we think of today. But at this point, we have accepted precedent, and Congress has amended the law, assuming that it means you can't discriminate in contracting. And if you think of an admissions decision as a contract, then possibly Harvard would be covered by that, even if it gave up federal funding. But let me tell you, they're not going to give up federal funding.
Parsing this immigrant pool again, we've got some questions here from the audience. It said, one's asking, it seems to me the legal arguments on affirmative action shoehorn the issue into narrow points that miss the uncomfortable and obvious differences in culture, upbringing, values. A disproportionate number of Black people at schools or elite firms are immigrants. Didn't hear this issue raised. So this is sort of the question, and this is what Justice Alito, I think, was getting at with his argument, where he ultimately brought in, how do we define who gets this benefit, right?
I think Justice Kavanaugh at one point actually asked the question straight out: could there be a benefit, a preference, a tip for the kids of immigrants? And the response was, as long as you're not limiting it by country or race of the immigrant, just broadly immigrant, that would conceivably be legal. That's a different sort of thing. And I thought where this question was going was a different direction, because the first half hour or so of the argument, way back this morning, it feels like it was 2 weeks ago at this point, because we had 5 hours. It felt like this was going to be, and it could still be, the way the opinion writes, with a focus on the essay, the personal essay in your application. How much can you write about your racial background? What if race is key to your identity and your experiences? Can colleges take that into account? More broader than the immigrant question alone. But the answer there was that, well, that's diversity of experience and so forth, rather than box checking. And the preferences that we're seeing, or the statistical admission rates, seem to be based solely off what box you check at the outset of your application.
Well, there's the box checking side, but there's also the very evil outcome of having to hide your identity if you happen to be Asian. And that came out in saying that in your essays, you don't want to talk about your experience if you happen to be Asian, about your cultural experiences, because that could give you a penalty, because they could read through it, even if you decide to check on the box, I refuse to identify. So, and the other thing about the checking of the box, it was very clear when Harvard said, well, it's what you yourself decide. So it's voluntary. You can check whatever you choose. And so that you can be, your great grandparent might happen to be American, a Native American, as that was pointed out, to great laughter in this room that I happened to be hearing. The oral arguments with, there was a bunch of people that we were all sitting together to hear it. And when we started going down to say, well, does it count if you have a great grandparent, or is a great grandparent? Well, what if you only have family folklore that says that you have a Native American in your family? So does that qualify you? And why should we give credit? Why should we give an extra point to that applicant because of that? And these are very important moral questions that we should be asking us. Why are we defining ourselves and pitting ourselves against one another for those silly reasons?
And I will point out that the Solicitor General of North Carolina did suggest that it would probably be dishonest to rely on family lore in this context. Notably not, this was not what the attorney Seth Waxman for Harvard said, given that one of their law professors did that in the application process. She's now obviously in the U.S. Senate. So let's see, here's another interesting piece from a non-lawyer. And so maybe, Wei-Wah, this would come back to you, but anyone can answer. Listening this morning, I found myself thinking perhaps a compromise could be to have Harvard apply its current metrics to the ALDC applicants. And we can explain what that means. These are sort of the exception applicants, the non-race exception applicants, and have a strict colorblind non-racial filter to everyone else. After all, historically, aren't legacy applicants descendants of racially, ethnically selected bias groups?
Okay, first of all, on these legacies, everybody likes to pick on legacies, okay? And I want to point out that if you believe in nature or nurture, very often legacies have an environment in which they are able to perform somewhat better just by osmosis. Or if you believe in nature, there will be some proclivity to performing better in certain fields. And certainly we know probably families of doctors, families of musicians, families of whatever. And so you should not be penalized for that. And we should not be judging kids based on their ancestors. That's what's coming out, right? So if they are not good, then they should be disqualified. There was actually a study some years ago by Yale on alumni children, and they found that their kids did get into Yale at higher rates than the general population. That's not a surprise, right? For exactly what I said. But they also found that these same kids got into the other cohort schools at higher rates too. See, it really does have that same effect that I'm talking about for the nature and nurture. Now,
although you do have to disaggregate as well, that because that ALDC, it's athlete, legacy, dean, meaning rich folks that could donate an art museum, as came up, and C is children of faculty and staff. So I think the athletes and the A and the D might be lower qualified, but the legacies indeed tend to be of a higher academic matrix than the general applicant pool.
And for you all over here, I would suggest that faculty kids tend to do better too, just by the nurture part. If you're surrounded by professors and you listen to things, that's going to happen, right? And so it's not, we've all heard about faculty brats. Most of them are smart, okay? Not every one of them. But they should not be penalized for being a faculty's kid. But
they should also not receive an advantage. And just the fact that they're getting in at higher rates than other students is not indicative of that. But like if you look back to Grutter versus Bollinger in 2003, the University of Michigan was giving 1 point to students who were the children or grandchildren of University of Michigan graduates. 1 point. By contrast, they were giving 20 points off the bat to any African-American applicants. So it was very, very small. But just as a matter of policy, I'm not talking about law here. Why do that? Why do that? Why is that a good idea? It's true that being reared in a environment where your parents are college grads, that's kind of an advantage, and yet you still don't make the grade. I don't see any reason to give anybody that extra point. I don't think it's illegal. And the Supreme Court is all about law. They're not about what's good policy. But for the record, I think it's bad policy.
Okay. I believe in Gratz in the Michigan case. I think being a concert level oboe player, to bring it back to today's argument, was worth 5 points. So race was 20, oboe was 5. I think Olympic gold medal was also 5. And children of faculty 1.
Yeah, and when it's that big of a disparity, you can see why the universities, if they want to have this sort of racial balance, aren't willing to go completely race neutral, right? I mean, there's ways to. Yeah.
One thing that's interesting, Ward Connerly, who was a regent for the University of California back a few decades ago and was responsible, he chaired the Prop 209 campaign that I co-chaired. And he also voted and led the effort to adopt a race neutral policy at the University of California. He tried to get the University of California to get rid of its legacy preferences as well. And the very same people that wanted racial preferences also wanted legacy preferences. So it was odd that often we were blamed and it was used as an argument. We have to have racial preferences because there are legacy preferences. When in fact the legacy preferences were very small relative to the, but I'm not for legacy preferences. Ward Connerly was not for legacy preferences. Yeah. And the people that really wanted race preferences also really wanted legacy preferences.
Yeah, and the universities want them, anyone who's been on the other side of university development officers knows exactly why the universities want them, right? I mean, yeah. But before we wrap up or sort of get into final predictions and things like that, just wanted to, there was one piece we haven't touched on that I thought was interesting when the Solicitor General was first coming out, particularly at the first part of the argument, hitting hard on sort of the service academies and military needs here. And there was some back and forth on that. And anytime I hear the military, precisely for what Weihua was talking about in terms of the World War II context, the justices get a little nervous when it comes to the military, things like this. Anything to make out of that, folks? Any reactions?
Well, that's, she was learning, the administration was learning from what worked in Grutter, and the brief by the military officers, like the brief by the leading corporations, which perhaps now is less convincing, but the military brief was significant. And so generally, historically, the Supreme Court does defer a lot to the military. And I think it was probably a smart division of argument. I mean, there were three other lawyers, two others defending UNC, one other defending Harvard. And so it was smart of her to lead with that point. But she got questioned several times about, well, okay, why does that have to deal with universities? What about universities that don't have ROTC programs if you're talking about a pipeline to the military? What about the military's own programs? What about enlisted men go straight from high school, and very few enlisted have college degrees or college experience. So it's a more complicated factor than just invoking the magic word military and then having deference, to get back to Justice Thomas's concern.
Yeah, I agree with Ilya that it was smart to bring up the military point, given how much play it had gotten in Grutter and Gratz back in 2003. And unless I'm wrong, we're in a situation where 9 justices, none of them with military experience. In Grutter versus Bollinger, they'd all been to law school, so it was hard to tell them, you don't know anything about what things are like in law school. They've been in law school, and some of them had taught in law school. But I think none of them have been in the military, so there's a little bit of I shouldn't stick my neck out on this issue. But the truth is, I think in the end, the same rule against race discrimination matters there as well. But it's distinguishable enough to where I don't remember which justice it was that was basically saying that's a different question now, isn't it? And we can put that question aside because that is distinguishable, and it surely is. But I think it's true that just as a matter of optics, given how well that issue had done in 2003, it was smart for the Solicitor General to bring that up in that way.
So let's get to predictions, and we've got a question here that sort of says, what are the nuances of a likely SCOTUS ruling? We've heard Ilya, he says 6-2, 6-3 is the outcome. What does it look like? Let's assume they do rule for the plaintiffs here for students for fair admissions. What kind of ruling would it look like? And Ilya gave his meta prediction first, so we'll start with Gail, Weihua, and then we'll come back to you, Ilya.
I'm very glad that Ilya went first because, oh my gosh, in 2003, I predicted that the court would rule against racial preferences. And it didn't. It looked to some people like, well, they went one way on one case and the other way on the other case. But no, it was a wipeout for those who oppose racial preferences, because the Gratz decision, which just said, you can't be really obvious about it. That was not a victory. That just meant every university in the country knew that the thing to do is just don't be obvious about it. Don't attach, really clear numbers to it, but otherwise you can discriminate all you want. And so I am going to say that I have no idea what the court is going to do, because really, I was so surprised that we did as badly as we did in 2003. For me to say anything positive would jinx it. So I don't want to jinx it.
I certainly wouldn't want to jinx it either. I would have to defer and say that I like what Ilya is saying here. Maybe what we could do is put together a betting pool and see what the odds are, and then that we'll have a much better sense of what the actual outcome will be. But I'm cautiously optimistic, but I think it's going to be what results in the decisions. What is the language? What will people be parsing for years to come as to how you can define it and work by these, and then the execution of whatever results?
I should add 2 things. That one is that, if we're actually putting money on this, I'm with Ilya. But we also need to remember that regardless of how the case comes out, colleges and universities are not going to jump to comply with it. If it comes out very strongly against racial preferences, that is just going to be the beginning of a long struggle, just as it was in Brown versus the Board of Education. There are a lot of things that will need to be done before we can expect colleges and universities to really deal with the students who apply for admission on the basis of their character, their credentials, and not on the basis of skin color.
Although you have seen definitely a material difference in California, right? I mean, the universities have continued to fight to work around it as best they can, but you've seen a material difference since '96, right, Gail? I mean, you've been on the front lines there.
They work very, very hard to avoid Proposition 209. But the data, particularly in the first few years, the data was excellent. It showed that African-American students were getting higher grades. They were more likely to major in science and engineering, and their graduation rates were going up. Not just, graduation rates were going up anyway, a little bit, but the graduation rates for African-American students went up particularly because finally they were competing with students that had credentials that were in the ballpark with theirs, and they were doing splendidly. Just up the road from me at University of California at San Diego, prior to Prop 209 going into effect, there was only one African-American honor student in the whole class. And that class was, more than 1,000 students. But as soon as Prop 209 went into effect, the honors rate for African-American students was pretty much the same as for every other race. It was like, yay, we really won. There's a lot of avoidance, but there's also the need to comply to some degree. So we've
absolutely. Ilya, you want to
let me
refine your analysis?
Let me explain it. So typically in controversies with high political salience, high profile, John Roberts is thought of being as the potential squish among the conservatives. That matters less, as we learned last term, because there are now 6 so-called conservative or different variety of Republican appointed justices. On this issue, however, both based on his history and in the type of questioning he engaged in today, he is not going to be any sort of squish. It's hard to see. So he is not the 6th man today. He's either the 5th, meaning the deciding vote, or maybe even the 4th. Amy Coney Barrett, Justice Barrett, she was most concerned about an end point, and of course, none of the lawyers supporting either Harvard or UNC were able to define exactly when racial preferences would be ended. If anything, Kavanaugh might be the most squishy on this stuff, but then he's likely, as he has in other cases, to kind of write a hand-wringing concurrence. Explaining how he feels for the other side and understands that it's a hard-fought issue, but ultimately, he'll side with the majority. And likely thing is going to happen again. I can see Chief Justice Roberts taking this opinion for himself and building on his previous writings about how it's a sordid business, this divvying us up by race. The way to stop racial discrimination is to stop discriminating based on race. And then you will have to read between the lines with whatever concurrences about all the weight that's placed on these personal essays or experiences. And that, I think, is ultimately where university admissions offices are likely to go. We want someone who has the experience of being discriminated against or what have you. Or maybe they will lean into socioeconomic, because after all, Harvard took some heat when it came out that most of their Black students weren't even African-American. They were African or immigrants from the Caribbean. And so you might see some more nuance in that regard, and maybe more consideration of the Afghan experience versus, another wealthy other kind of racial minority or something like that. But that's where I stand. That's where I'm in the actual vote counting. I count Roberts as either Roberts or Barrett as number 4 or 5 there, and so it seems I'm pretty confident that they'll overturn Grutter or at least write it in a way that'll effectively overturn it. The real question is, will they go whole hog and overturn Bakke, and what they'll do with diversity as a compelling interest in the first place?
There's another danger here, also they could think they are writing an opinion that comes down like a sledgehammer on racial preferences, but if they word it in a way that isn't really tight, there will be a way around.
I think that's right. I agree with Ilya on the count. I'll go on record as saying that, although he's obviously more of an expert on Supreme Court watching than I am. I will say that I agree Chief Justice Roberts is likely to write the opinion. I will say he may take a little bit of the bait from Justice Gorsuch, and I think there's still some chance that it could be a Title VI opinion principally. It would sort of comport with Justice Roberts' sort of incrementalist constitutional avoidance norms if he writes the opinion that way. But I didn't see anything from Justice Kavanaugh or Justice Barrett that leads me to believe that they're not going to come out with a majority on this case. I'm not exactly sure how it's going to be written, but I think that's the answer. So want to thank each of you for coming and sharing your time. And I want to thank all of our audience for both joining us after the delay and sticking with us for the hour. So Ilya, Gail, Weiwa, thank you for such an insightful and timely conversation. Before we close, I'd just like to invite our public audience to browse the Manhattan Institute's research, subscribe to our newsletters, and if you're able, please consider supporting the Institute at the link you see below. The Manhattan Institute is, of course, a nonprofit organization, and our work depends on the support of people like you. Thank you.